right, welcome back. Thanks for coming by. I am the Lincoln Lawyer. Have a seat. Enjoy the show. So we're going to talk about litigation with entities. This is a very interesting area. Most people have no clue what it involves. But let's do hypotheticals. So let's say I have a small business that gets sued. A small company, few to no assets, maybe a bank account, some personal property, inventory, yada yada. What am I going to do? Am I going to answer that bullshit lawsuit? Am I going to go to court, spend 5, 10, 20K, litigating this bullshit? No, not even remotely close. Fuck that. I'm going to let him get his default judgment and try to collect that. All right, try to collect it, see what happens. I'm going to use that money to go and open another business, transfer all my assets, all my liabilities to the new one, and keep operating. What the hell is he going to do? He can't sue that. There's no way he can sue that legally. So that's the simple way to do it, okay? But of course, most people fuck it up. It sounds simple, but they have no idea what they're doing. So what they'll do, they'll open one company. They'll freaking put everything that they own in that business into that one company. They'll have their bank accounts. They'll have their vehicle. They'll have their inventory. They'll have their leases. They have all the contracts in that company, their trademarks, their equipment, whatever. Everything goes in there, and that is the stupidest thing you can do. Look, if you don't know what the fuck you're doing, just hire someone, okay? Pay less now or pay more later. It's not that difficult. You need to segregate your assets. It's a very simple concept, okay? The company that signs contracts should not have any assets except for maybe a few bucks in a bank account. I don't know how much more simple it can be. Don't lump everything you own in one entity that you can lose, all right? Lesson number 1, all right? I hope that's clear enough. So let's say I want to sue a company now, okay? Small to medium business. I mean, you're gambling. This is a gamble, okay? If you're suing a major company that's established locally, multi-million-dollar business, it's got a brand name, it's got trademarks, it owns a lot of assets, you've done an asset search, it's got a lot of members, let's say officers, directors, owners, shareholders, whatever, then yeah, probably that company is going to have insurance, and I'm going to get into insurance at the end, so that's probably a good bet to go after, okay? I'm talking about small to medium businesses that can pack up and move on and reopen in 2 weeks under a different name. So you are gambling suing that kind of entity, okay? So what's the strategy you might want to take if you really need to go through the lawsuit like that? So number 1, you probably would want to sue somebody personally who's involved in that company, let's say an officer or director, shareholder member. Try to find a reason to sue them personally. Well, it's some kind of conduct outside of the scope of employment. It's kind of difficult to do most of the time, so not really available, so you're just probably not going to get that. But if you can, then do it, obviously. Then the other thing you can try to do is attempt to pierce the corporate veil, as they call it. So this just basically removes the liability shield provided by state law. Now you have to prove in court through evidence substantially that the company was an alter ego, as they call it, of the owner or owners. That would pretty much mean that the company had little to no separate existence as a legal entity, okay? So the money was commingled, personal and business funds were commingled in accounts. The company funds were used to pay for personal expenses. No records were kept, no taxes were filed, no votes, no meetings, stuff like that. Basically, the company might not even conduct any business. It might just be there for the personal benefit of the owner as a pass-through company, some kind of a separate entity to hide their assets. So in that case, it would be pretty cut and dry. If you can demonstrate that, then you can probably pierce the veil of that company. In most cases, it's pretty difficult. If the company is doing business, if it's got some records, if it's filing taxes, if it's got a separate bank account, probably going to have a hard time proving alter ego, okay? So strategy number 3 is to go after the insurance, and that is the best case scenario, okay? If your liability is covered by insurance, then the company has an obligation to defend their insured. So they're going to provide the defense. And most of the time, you're actually likely to receive multiple settlement offers up to trial and through trial. Okay, so they generally will avoid litigation because of the uncertainty and the cost. So if they stand to lose, let's say 50 to 100K in legal fees, and their liability, they're being sued for, let's say 200, 300, 400K, well, they're probably not going to risk losing 500, a million, whatever in total, including legal fees and the judgment, maybe appeal, etc. And they're just going to offer you a settlement of maybe 200K, 150, 300, whatever it may be. So the lawyers that they hire are very experienced, usually professional. They're going to go through discovery. They're going to do everything more or less by the book. They'll certainly have their own dirty tactics that they employ, but generally they know what they're doing, and they're not going to make it easy, okay, if you're suing an insurer. But generally, obviously, if you win the case, then they're going to pay. So that's a given. You don't have to go through collections, post-judgment collections, discovery process. So that's definitely a big plus. So always suing an insurer is definitely, should be the best case, okay, to consider. All right, so that covers that area, and I want to just jump into the Uniform Fraudulent Conveyance Act very briefly. Okay, that is pretty much, I believe, adopted in all but 5 states. That's supposed to protect creditors. In my experience, it's rarely used to attempt to challenge a conveyance, even if it's within the clawback period. It's generally 1 to 2 years, depending on the state. And even more rarely is a conveyance set aside as fraudulent. So if even if an asset is transferred within the clawback period, right before litigation, and it's a bona fide transaction, let's say a bona fide purchaser buys something at arm's length transaction, and it's not a family member, it's not a spouse that had title transferred to them, and you still control and own the asset, the debtor still owns it, has it in their control, then most likely that transfer will not be set aside, even if it's generally intended to hinder creditors' collections. Okay, so because the rights of the purchaser, the bona fide purchaser, will definitely usually outweigh the creditor's rights, because if they had no notice of the liability, they had no notice of the lawsuit, then it's unlikely that transaction will be reversed. Okay, so generally I will advise, even if you're staring down the barrel of litigation, definitely employ asset protection strategies to remove and transfer your assets that may be subject to liability, subject to seizure. Particularly movement to offshore is definitely a good option most of the time, if possible, and that would pretty much put any kind of asset moved there out of the reach of pretty much any creditor. So just something to think about. I would say maybe 10% of all conveyances, of all transfers, would be set aside, maybe less than that. So it's not really something to think about. It's better to just go ahead and transfer it than not transfer it and let it be seized. You're definitely going to have it seized, but if you transfer it somewhere under the supervision of a professional, of a competent specialist, then there's a very good probability that it will not be deemed fraudulent and will not be clawed back. So, okay, so that's about it for today. I hope this is helpful. Please write any questions you may have at the bottom. Like, subscribe, be cool, take care, and stay out of court.